Hello everyone, welcome to the discussion on intermediate paper number 5, Business Law and Ethics. Previously, we had discussed on the various important aspects of chapter number 2 of Indian Contract Act 1872. Today, we are having a short conversation regarding the most probable questions or repeatedly asked question in previous exam of Business Law and Ethics. There may be questions which are not covered in this lecture, but we are trying to cover the most important question repeatedly asked in previous exam. So students are suggested to watch the lecture on chapter number 2 before proceeding further. So one of the most important question and repeatedly asked question is, what are the essential elements of Contract Act 1872? As per section 10, there are what are the important aspects or elements of a valid contract? There shall be an offer and acceptance. There should be a legal intention to create legal relation. The agreement shall be for a lawful consideration. The parties to the contract shall be competent to contract. There shall be a free consent between parties. The object and consideration of the contract shall be legal. The terms of the consent shall be certain. The agreement is capable of being performed. So, we know what are the elements for a valid contract. But the most important thing is to know where to answer these points. So, let us think of a question where this is the answer. One can be, what are the essential elements of a valid contract? So, you can answer all these points. Another question can be, what are the essential elements for a valid e-contract? They're also same point only. The most probable method of asking is, there will be a scenario given. Based on the scenario, you will be asked to give a legal opinion regarding that scenario. For example, A, aged 20, entered into a contract with B, aged 14. Is the contract valid? Answer, not valid, because the parties to the contract shall be competent to contract. Or for example, Mr. A shown his knife and asked Mr. B to enter into contract. Is the contract valid? No, because there is no free consent. Like based on such an example, based like such example, you should be able to identify what is the question. Many times students will be knowing the answer, but not able to understand or arrive at a conclusion what will be the answer. So by understanding the concept properly, students will be able to understand, able to answer. So one of the most repeatedly asked question is essential elements for a valid contract. Next, void agreement and voidable agreement. So what is void agreement? What is voidable agreement? Voidable agreement is by void at the discretion of a individual. You can go through this. This is a possible question. So we know one of the essential elements for a valid contract is to have a consideration, valid consideration. So there may be a situation where consideration does not exist and is the contract may be valid. So what are the cases? So these are the event. This is a possible question. A father giving gift to son, contract is entered. There is no consideration. Is it valid? Of course, it is valid. Consideration can be in the form of love also. But these are all exemptions. Next, free consent. Opposite, coercion. The party entering into a contract should be entered with free consent. They shall not be coerced to enter into contract. Students are asked or requested to go through. Another probable question is coercion versus undue influence. Differentiate. So, a father asks his son to enter into a contract which is not in the best interest of the son. So, that is a classic example of undue influence, using of one influence to wrongful gain. Whereas, where a party against their will is forced to do something that they are not interested is coercion. Coercion versus undue influence, free consent. Another, what is fraud? Everybody might be knowing. Misrepresentation versus fraud. A misrepresentation may be unintentional, and the degree of the penalty or degree of wrong is comparatively higher in case of fraud. A fraud is indeed a misrepresentation, but a misrepresentation is not always a fraud. So you're requested to go through the difference between misrepresentation and fraud. What are quasi contracts? There are no ex- explicit contract available, but based on the circumstances, a contract has been formed. For example, a person find a purse in a bus. So even though there is no contract, a implicit contract has been enforced. What is contingent contract? Example, insurance based on the happening or not happening of an event. These keywords are very important. Even if you're understanding the concept and writing in the exam, the invigilator will be looking for a keyword. Based on that only, you will be able to score. Another important topic is discharge of contract. What are the different modes of discharge? Discharge by performance, by agreement, by lapse of time, by operation of law, by impossibility of performance, by breach of contract. So students can go through that. Once the content of the contract has been completed, all the terms and conditions has been satisfied, through performance it can be discharged. An agreement is entered to saying that the original contract is over, then that way also it can be discharged. And contract may include certain time for completion of contract. Once if it is not completed by that time, by lapse of time, it can be discharged. It can be because of operation of law, example, death, insolvency, merger, etc. When a contract is entered, but later on it is become impossible to perform, that way also it can be discharged. When the contents of the contract has been breached through breach of contract, it can be discharged. These are direct way of answering. You may be asked indirectly. Suppose Mr. A enter into an agreement with Mr. B saying he shall supply certain goods on so and so date. But that day he didn't complete the contract. So because of breach of trust or breach of contract, conditions has not been satisfied, the contract shall be discharged. Like that, based on the circumstances, you should be able to identify on what kind of discharge it is. What is the novation? A con- Mr. A enter into contract with Mr. B. Later on, another contract has been entered saying the first contract is over. That is novation. A contract entering and dissolving the first contract. Agency. Who is a principal? Who is an agent? What are the rights and responsibilities of an agent and a principal? And principal shall always be responsible for the acts of the agent, except where agent works on fraud or purposefully deceiving the principal. So, what are the rights and responsibilities of agent and principal? You can go through. Another important question can be contract difference between contract of indemnity and contract of guarantee. This is a repeatedly asked question. Contract of indemnity, example, insurance. There are two people, indemnifier and indemnified. Insurance company is the indemnifier, the insured is the insured indemnified. Whereas in the case of a guarantee, there are three people. Mr. A give 10 rupee to Mr. B. Mr. C says if B does not pay back to A, C will pay. So in this case, A become debtor, B become creditor, C become surety. Suppose Mr. C says I will pay 5 rupee, Mr. D will pay 5 rupee. Means C and D become co-surety. If you understand the concept, you will be able to answer easily. So, what are the things? Indemnity, there are two parties. Contract, there are three parties. Primary liability is on indemnifier, whereas in the case of guarantee, it is on debtor. So, this way you are requested to go through the concept and able to answer. Okay. And one other humble suggestion is unless you are 100% confirm about this section, please don't quote section in answer, because even after answering everything correctly, if you quote section wrong, your answer is invalid or invigilator may not be giving marks for that. So unless you're 100% sure, never quote section. Rights and responsibilities of surety. You can go through. Another possible question, bailment and pledge. What is the difference? So pledge is regarding movable property. Bailment can be both. That's all. In the case of bailment, there are two parties, bailer and bailee. In case of pledge, there are owner and pony. What are the rights and responsibilities of bailer, bailee, or owner, pony? These things you can go through. If you know the concept, you will be easily able to answer. Bailer's obligation, bailee's obligation. These are all important. Okay. Suppose Mr. A give his car key to Mr. B. Until Mr. A pay back the money, Mr. B will keep the car. So, what are the rights of A? Once a payment is done, A has the right to get his car back. What is the right of B? Right, B has the right to get the money back. He has the right to keep the car. Suppose Mr. A give his cow to Mr. B, and the cow give birth to a baby calf. So the calf belong to whom? These are all practical questions. There you can just go through the topic. So does Mr. B have the right to retain calf? No. Once the payment is done, mother and child should be returned. Another example, Mr. A gives some fish as pledge to Mr. B. Fish is a perishable good. 1 or 2 days only it will be good. What Mr. B sold the fish, is it valid? Of course, it is valid. Perishable goods and all mercantile rule of mercantile you can go through with the consent of Mr. A. If Mr. B can act as to sell the goods, it is all valid only. So students are requested to go through the topic. Bailment and pledge. Difference you can go through. What are the rights of each parties you can go through. So these are the possible questions. Lastly, contract and decontract essential elements are same only. Don't get confused. Hmm. Minimum you should be aware of these topics. These are for information purpose, and you are requested to minimum go through this much topic in the chapter. Over and above, you should be going through entire chapter, which is time confused consuming, and it is a proper way to do. But as a quick revision, you should be aware of this much at least. Thank you for watching.